Thank you. Peggy Bensinger from the Attorney General's office. As Linda said, I'm going to talk a little bit about the takings clause of the United States and Maine's constitutions. It's, as everyone else has struggled with today, it's a massive subject area, and I'm just going to touch lightly on it. The takings clause of the Fifth Amendment of the United States Constitution and Article 121 of the Maine Constitution, as most of you know, prohibit the taking of private property for public use without just compensation. So the obvious part of that, the physical occupation of a person's property, that's the classic taking. But the United States and the state constitutions also guard against certain regulatory interferences with property owners' interests or use of their property. So I looked at two questions here. The first was whether Maine's regulation of the quantity of groundwater a property owner may withdraw or use from the property might constitute an unconstitutional taking. And then the second question I looked at, which is related but a little bit different, is whether a taking claim could be successfully made if Maine simply changes from being an absolute dominion state to a state which utilizes the reasonable use doctrine or one of the other doctrines that Paul talked about. So the first question, whether our regulation, some of which is going on, as you were just told, and as most of you already know, whether the regulation of the quantity of groundwater you can use and withdraw from your property might be a taking. In takings questions in general, the courts have used two separate analyses. One is called the per se analysis, and that is whether something is a taking on its face. And then the second type of analysis is called the ad hoc analysis. That's a case-by-case, very fact-dependent analysis, and it's a lot harder to answer a question under that analysis because it depends on the nature of the regulation. I'll get into that in a minute. So with regard to the per se rule, certainly I think we can safely say that our current regulations and regulations that have been discussed to date with regard to the withdrawal and use of groundwater from the property would not be found to be a per se taking by the courts. The second analysis is a little bit more complex, the ad hoc analysis. It really depends. The courts apply a three-part test. It depends on the nature of the regulation you're talking about. It depends on the economic impact of a particular regulation, and it depends on the extent to which the regulation would interfere with property owners' legitimate investment-backed expectations for the use of that property. Utilizing, well, I'll go into it in more detail in a minute. The second question of whether a taking claim could be made if Maine changes from an absolute dominion state to a reasonable use, for example, state. I don't think that would result in a finding by a court of a per se taking, because under a per se taking, you have to be basically either physically, as I said, physically occupying or prohibiting the use of the property or diminishing the value of the property to zero, basically completely depriving a property owner of all economic use of the property. So I don't see that a per se taking by changing from an absolute dominion doctrine to a reasonable use doctrine would be found by the courts. The ad hoc or fact-specific taking analysis I'll talk about in a little more detail because I think that's the one a court would use in the analysis of any changes that Maine might make. It's hard to talk about in the abstract. The courts have refused to adopt any bright line tests, as they often do, as to whether regulations enacted by governments would constitute an unconstitutional taking. So I'll talk about the three-part test that basically the courts adopted under an old case called Penn Central. And in that case, the court said the following three considerations are instructive in determining whether or not there's been a taking. And the first is the economic impact on the property owner. And there's been some reference, to that already today. The courts have found that the diminution in the value of a property, even a significant diminution, is insufficient to demonstrate a taking. And there have been cases across the country, and one in particular in Maine, where they have found very significant diminutions to not constitute an unconstitutional taking. In California, there was a case where a 46% diminution in value of the property that involved a pension plan, actually, was not found to be a taking. In a case that I litigated involving denial of a permit to build a house on a sand dune called Wire versus the Board of Environmental Protection, the court found that no taking had occurred, even though the denial of the permit to build the house, well, without a permit, the court found that the property was worth $50,000, and with the permit, the court found that the lot would have been worth $100,000. So the court there found that that did not constitute a taking, and there wasn't a significant enough diminution in value of the property. The fact that a property owner might not make as much profit on his or her investment as he or she would have hoped for is also not a basis for a taking. And there are quite a few main cases on that, which I've cited in my little memo. In a case involving the Land Use Regulation Commission, the court found just because a property owner could not use his property in the most profitable manner, that doesn't mean it's a taking. And again, in the Wire case that I litigated, Mr. Wire presented evidence that he had paid $10,000 for his lot when he bought it, and he could have earned $100,000 if he could sell it with the permit. Instead, his only option was to sell it to an adjacent landowner for $50,000, and the court found that the loss of that profit of $50,000 was not sufficient to constitute a taking. One of my favorite quotes in takings law is the Maine Law Court in the Seven Islands, the Lurk case, said, "The loss of future profit provides a slender reed upon which to rest a taking claim." So any challenge to a new regulatory scheme or a new groundwater or change in legal doctrine that would apply to Maine, a court would have to evaluate in a fact-specific manner the value of the landowner's claim, the claimant's property, in light of the new law, the value of it before the new law and the value of it after the new law, and determine whether the value of the property had been so severely diminished that it would constitute a taking, an unconstitutional taking. That leads right into the second part of the analysis, which is what were the legitimate investment-backed expectations? The United States Supreme Court has said, and this goes to, I think, Ms. Manning's point earlier, that a landowner does not have a constitutional right to a frozen set of laws and regulations governing his or her property. In the case of Lucas versus South Carolina Coastal Council, in which a taking was found, actually, but the court said, the U.S. Supreme Court said, that a property owner should necessarily expect the use of the property to be restricted from time to time by various measures that the legislature might adopt in the legitimate exercise of its police, the state's police power. And the courts have also said that those who do business in an already regulated field they can't object if that field, if the regulations increase or become more strict in the use of the property. And for example, the courts have said landowners are not entitled to rely on the maintenance of the same zoning framework with regard to their property. Although a lot of zoning laws do have grandfathering clauses, but you can't buy a piece of property and sit on it for 30 years and then expect to be able to do the same things that you could have done with it 30 years prior. That was a big issue in the Wire case because the man had owned the property for quite a long time. And he said, well, I expected to be able to build a house on it. One of the things the courts consider in this legitimate investment-backed expectations analysis is whether the property owner knew of actual or potential regulations that might affect the investment potential, or whether they should have known of actual or potential regulations when they purchased the property. So that's an analysis. Again, it's very fact-specific, and it depends on the timing of the purchase of the property. So it's hard to make any blanket pronouncements, but I'm just trying to give you the lay of the land in takings law. And as I should have said from the beginning, this is a legal area that changes every day, and they have conferences on it all the time. It's a very dynamic framework.